level wherever it may go, because this transcript, your voice will have to be on tape, so, or recorded, so. So if you want to testify, get your rec information heard, please do at this proceeding.
Good morning, everyone. This is the Board of Adjustment. Thank you so very much for coming out. We appreciate you being with us today. And we have several cases on our docket, so we would ask that, as they say, everyone that has a cause to draw near and be heard. So good morning. I would ask everyone, if you could put your phones on silent, or if you can, turn them off. It really does help everyone's comfort. So thank you so very much for doing that. Having said that, this is the meeting of the Escambia County Board of Adjustment for April the 17th, 2024, and it is now hereby called to order with six members present. Is that right? Will the clerk please swear in members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of the staff's resumes have previously been provided and remain on file for reference. The board has previously recognized the staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to present expert testimony in these proceedings? Seeing none. The BOA meeting package for April the 17th, 2024, with the Development Services staff findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do I have a motion?
Motion.
We have a motion from Willie. Do we have a second? Second. We have a tie for second place, and so we'll go to our Chairman Emeritus, Mr. Smith. All those in favor of this motion, please raise your right hand. Let the record reflect unanimous approval by the members of the board. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of these legal advertisements.
Motion.
We have a motion. Do we have a second?
Second.
We have a second. All those in favor, please raise your right hand. The motion passes unanimously. Members of the board, have you reviewed the resume and transcript for the Board of Adjustment meeting held on March the 20th, 2024? Upon your review of the resume and the transcript, are there any additions, deletions, or corrections that need to be made? Seeing none. The chair will now entertain a motion regarding the hearing resume for the Board of Adjustment meeting held on March the 20th, 2024.
Motion.
We have a motion.
Second.
We have a second from the Vice Chairman. All those in favor of this motion, please raise your right hand. The motion passes unanimously. We now will turn to the purpose of the Board of Adjustment and the conduct of this meeting in particular. And our Vice Chairman will advise us of these particulars.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made a part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision will be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record.
We now turn to ex parte communications. All written or oral communications outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commissioners Resolution 93-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and to describe the communication. We now turn to our first case. This is case number CU 2024-04, 1800 Patricia Avenue The request is to allow liquor sales in a separate building on site in LDMU zoning. Meredith Bush, agent for Everest Commercial Investments LLC owner. And I see that Mrs. Bush is with us today. Before Mrs. Bush makes her remarks, it's necessary for me to ask, have any member received any ex parte communications regarding this case? Seeing none. Has anyone obtained knowledge or information obtained from a site visit or other sources concerning this matter? Seeing none. Is there any board member who intends to refrain from voting due to a voting conflict of interest? Seeing none. Ms. Bush, would you like to make some opening remarks? I see that you are here, and also Mr., and I'm sorry, if I'm sure I'll mispronounce it, Mr. John Truskowski. Yeah. Would you like to make any opening remarks?
Sure. I'm happy to address the board relatively briefly. So you may recall we were here last month with the same matter, and there was a desire from the board that we do community outreach and specifically note that it was for a package store or liquor store in the mailer versus simply saying liquor sales. So we did that. We held a town hall meeting. There were about 15 people came out in support. We submitted updated application materials specifying that it was a separate or adjacent building, and specifying that it was for a package store. Staff's findings did not change. They're still in support of well, they changed simply to note that it was a package store, but didn't change in the fact that they support the approval, that we meet all the criteria. And again, at the community meeting, everyone that was present was in support of the package store. So I would simply ask that the board grant approval today.
Thank you, ma'am. I'll turn to Andrew. I noted that the findings were essentially the same. Would you like to give an abbreviated version, since we have discussed this at the last meeting fairly extensively, but for the purposes of the record, I think it would be good to hear your comments, particularly involving the package store sales.
Yeah, yes, sir. I'm going to turn that over to Allison Lindsay. She's the planner on this case, and she will give you her updated findings in that regard.
Good morning, Board. Allison Lindsay, Urban Planner Development Services. So as of last month, we did redo the findings. The only change in our findings, and we still were in support of, in the criteria A, the general compatibility, we did make the note that the proposal is to sell liquor on the same parcel that's independent of the existing restaurant building, and that it would be compatible with the surrounding land uses. And the other finding that was slightly changed was the criteria D, nuisance and hazards, that the proposed use would follow the operating hours that would be independent of the restaurant and should not generate unreasonable noise, glare, dust, smoke, or other nuisances to the surrounding properties. And all the other findings of facts remain the same.
Thank you. Board members, first, does the board have any questions for the staff? No questions for the staff. Are there questions for Mrs. Bush? No questions for Mrs. Bush.
I have just one question, quick question. How many were in attendance of that meeting from the community?
About 15.
Okay. Was it a better outcome after work hours? Did that work out better, or?
Well, we had not attempted one during working hours, but I do think that, you know, after working hours makes it where people are more available to come out, and this was held after working hours.
Okay, thank you.
Yes.
I've got two quick questions that I'm not sure if I asked last month. Do you know about how far is it from the restaurant site to the housing area, where the housing begins? Do you have any idea?
Staff, do you want to pull up a map? Or an aerial, perhaps? So you'll see there to the north of the property, on one side of the road, is a trailer park.
Right,
On the other side is a residential subdivision.
right. Do you have any idea about how far that is? It looks maybe half mile or so.
Speaking of Mike, man, it's only being recorded. Thank you.
I'm not sure if that was measured.
It's
I mean, it's not far, but
yeah, okay. It
Mr.
looks
Chairman,
not far.
It's a 1/10 of a mile to the, to Moore Avenue, which is the residential subdivision north and on the east side of the road.
Okay.
And I would like to add, it is, I go by there quite often due to my other occupation that I do have as a pastor on Sunday mornings. That area is heavily vegetated. So honestly speaking, I mean, they probably even know it's there, because when I say it's heavily vegetated, it's heavily vegetated.
And as to where Patricia goes down to Fairfield, that, if I recall, is also a fairly, not terribly long distance, but a fair
Yes, sir, it's about a 1/4 of a mile to Fairfield.
Fairfield, okay. Those were my two questions. Does anyone else have any questions? Would Mr. John Trusky like to speak?
Yes, sir.
All right, sir. Could you come up, and we would ask that you give your name and address for the record and be sworn in by our clerk.
Okay. It's John Truskowski. My address is 393 Gulfview Lane, Pensacola, Florida.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
Yeah, I'm here to just verify that this property is one of the few uses it's going to be able to be used for. It is on a floodplain area. I think it's going to be a service to the community. We take these abandoned buildings, we redo them, we remodel them, and they become an asset to the community. And the people that showed up at the town meeting were very much, in favor of. It gives them somewhere close to home to go entertain themselves and then get home safely. So all we're here to do is help the community. We're here to service the community. And as an owner of the business, that's my main goal. But that's it.
Board members, do you have any questions for
Is-
our witness?
I have a question. Is the same owner gonna own the restaurant that's gonna own the liquor store?
Yes, I'm that owner, yes.
It is the same owner, okay.
Are there other questions? Seeing none, thank you for your
Thanks.
testimony, sir.
Thanks, Joe.
Well, Board, I believe we're now at the point where we have to make a decision on the disposition of this petition. We've heard extensive testimony on it from last month. And we've, at least as far as I'm concerned, I had a couple of additional questions. In reading the file last night, it essentially is, as the staff has stated, has not changed the findings, but they have become more precise in that we are talking about a package store here. What are the comments of the board?
Mr. Chairman, I move that we accept staff's findings of fact and grant the conditional use.
We have a motion. Second. We have a second. Do we have any further discussion? I will say that I'm going to support this, and the reason that I'm going to support it is that given the location, and if I understood, I believe it's Mr. Jones's testimony at our last month's meeting, the area around this property is wetlands and is more than likely not be subject to development.
Yes.
It is located fairly, it is an island in one sense, and it is, in my opinion, located fairly far from both housing and Fairfield's, the intersection with Fairfield. I share the vice chairman's concern, though, that she expressed, or comment that this is a local road. But as I think Andrew pointed out, I believe the staff did, that it is not unusual, given Escambia County's growth pattern, and that we have these situations where you have businesses that are located on essentially local roads that are serving more than local traffic. So for those reasons, I know that we have to be very cognizant about these kinds of cases, and I'm satisfied that a vote to approve this, given the circumstances and geographically where it is, would be, in my opinion, something I could support. Are there any other comments?
I just want to add to that. You know, like I said before, I'm not a drinker, but that has nothing to do with my decision today. You know, I applaud you guys for going back to make sure the community understood exactly what was there. This is the second time y'all are here, and you know, I'm very satisfied because you know we have to be transparent with the community, and I hope the owner keeps that positive attitude, you know, of being a positive addition to the neighborhood. So, in order to do the right thing, because it does meet the criteria, I will be in support of it.
Board, hearing those remarks, if there are no others, those in favor of granting this petition, please raise your right hand. And the petition passes 5-1 with the vice chairman in dissent. And thank you, Mrs. Bush. We appreciate you being with us this morning. And now we turn to our next case. Our next case is V 2024-01. And if we could bring up the text. Okay, this is 335 Deerfoot Lane. The request is for a front setback variance. John Hollihan Jr. Is the owner. First, have there been any ex parte communications with the board concerning this matter? Seeing none. Has anyone obtained knowledge or information from a site visit or other sources? Seeing none. Is there any board member that intends to refrain from voting due to a voting conflict of interest? Seeing none. Mr. Hollihan, are you with us today? Yes, sir. Could you come forward? Please raise your hand and be sworn by the clerk of the board.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please state your name and address for the board.
John Clinton Hollihan Jr., 335 Deerfoot Lane, Cantonment, Florida, 32533.
Mr. Hollihan, would you like to make an opening statement, or would you like to have the board, the staff, give their findings first, and then you will follow up with your comments? It's depending on how you feel about that.
I think I'd like to let the staff do their findings first, and then I would like to make my comments, if that's okay.
All right, sir.
All right. Morning, Board. Andrew Holmer, Escambia County Development Services. Again, this is variance case 2024-01. Here we have our location map, our 500-foot radius zoning map showing the zoning is low-density residential. Our future land use map. Future land use is mixed-use suburban. This is a contour map that I included as part of the packet. As with all variances, being related to hardships on the land, I wanted to include this contour map, and I'll refer to it during my findings. This is an aerial map of the site. At the time this was taken, it was heavily wooded. It has since been cleared under the issuance of a building permit, and you can see to the rear, to the north of the property, is a wetland area. This is a public hearing sign posted on site. This is looking northeast along Deerfoot. And this is looking at the front of the property from Deerfoot. And that is southwest along Deerfoot. Looking across Deerfoot to a house across the street. Looking south along the west side of the property. Looking northeast across the rear of the property. It's looking north from the west side of the house towards the wetland area back in the trees. Okay, that concludes the photos. As to the findings, we're in a rather unique situation here. We have an owner-builder on this residence. I'm trying to think of the best way to approach this without throwing too many things at you at one time. County staff from both development services and building inspections go out to residences as they're under construction. They're checking for a number of things, but one thing they don't check and verify is building setbacks. that is up to the builder, in this case, an owner builder. County staff did go out. It did get sign off at the foundation stage, and the house is now currently dried in. It was after those visits that it was brought to staff's attention that the structure may be closer to the right-of-way than is allowed by the setback. The applicant, we requested that he get a survey. He did, and the survey showed that instead of the required 25-foot setback, it's actually 1 foot off the property line. This came about for several reasons. It's not a situation that to go out there, and I've been to the site, that it would necessarily jump right out. We're dealing with a 60-foot wide right-of-way, which is wider than a lot of them these days at 50, and a relatively narrow asphalt strip down the middle. The applicant measured his front setback from the edge of the asphalt, which is centered in the right-of-way at this case, which is not the front property line. So I'm going to go through the criteria here, beginning with saying that the requested variance is a request to reduce the required front yard setback from 25 feet to 1 foot for the construction of a detached single-family dwelling. As to the specific criteria, criterion 1, the parcels along this side of Deerfoot Lane slope to the rear, but this one is unique in having a draw that runs diagonally across the parcel. The elevation drop on this parcel from front to rear is 26 feet, and this feature, combined with the diagonal draw, create practical hardships for construction. Building across the draw would require a large amount of fill to be brought in to raise the foundation and to slope the land away from that foundation for proper drainage. That action would have the potential for negative impacts to the adjacent wetlands. And if you could go back, to the contour map. Thank you. As you can see, from the contour lines there, that draw runs north to south, diagonally across the property. And the house was pushed forward to avoid that and the potential for erosion. As to the second criterion, the need for a variance in this case is due to actions by the applicant. He measured the setback from the edge of the pavement instead of the right-of-way, with the result of not meeting the front setback. The pavement width at this location is 20 feet plus or minus within a 60-foot right-of-way, which is somewhat unusual, being narrower for paving and wider for right-of-way. Third criterion. Given the existing hardships, granting a variance would not confer the applicant any special privilege that is denied to other lands. Fourth criterion. Due to the existing hardships of the land, strict application of the LDC provisions would create an undue hardship. Criterion 5, this is dealing with the minimum to make possible the reasonable use of the land. The topography of the parcel would necessitate some degree of variance to either the setbacks or the size of the dwelling, but the amount requested is more than the minimum necessary to make use of the land. Criterion 6, granting this request would be consistent with the general intent and purpose of the Land Development Code and would not be injurious to the area or otherwise detrimental to public welfare. As to the recommendation, staff finds the request does not meet criteria 2 and 5. 2 being the one dealing with the special conditions and circumstances resulting from the actions of the applicant, and 5 being the one dealing with what is the minimum variance required to make possible reasonable use of the land, building, or structure. And that concludes the staff's findings.
Sir,
Yes, sir.
would you like to make some comments? Oh, and you have read the staff report, is that
Yes, I
correct?
have. Yes, sir.
Okay.
Well, basically, it's, to put it in layman's terms, I mean, I found the lot. It was the only thing I could use within my budget. And I brought in literally over 100 loads of dirt so far to build it up to where I could put the house and use the land. And I set back as far as I could. I've been fighting erosion like there's nobody's business, especially after that storm we had the other day. If I had set my slab back any farther than what I did, it would have been washed away by now. And granted, I made a huge mistake. And I'm just asking, excuse me. I took it for granted that when my slab inspection, I was told, you know, to go ahead and pour and for the rough in and everything, and I figured I was okay. I didn't even think about that. This is not the first time that I've built a house. This is the second one. I built one back in 1996 where I was my own contractor as well. I realize this is a huge mistake on my part, and ignorance is no excuse. But I'm just asking all of you, please, I'm not doing anything detrimental to my neighbors. They've all been asking, why'd you stop? Why did you stop? And I explained to them that I made a huge mistake. And if I can't get this, bottom line is I'm going to be broke and homeless. And all I want to do is finish my home and have something to leave my children. As he said, when I cleared the property out, it was like this, and you got 26 foot from front to back difference. And I've brought it up. I cleared out half of it. I cleared out 100 by 200. And I brought it up and packed it down, and I set my house back as far as I felt safe because of the erosion problems that I was having. And I just ask that you please consider and please have mercy and allow me this to finish my home.
Thank you. Thank you, sir.
You're welcome.
We, this board may have some questions for you, so if you could just stand by for a second.
Yes, sir, absolutely.
Staff, board members, do we have any questions first for staff and then for the homeowner?
I have a question for Drew. I'm not familiar with how you get a building house permit, development order, whatever it is to build a house. It seems like one of the things that the building department would look at would be a survey and some type of position of where the building will be on the survey. Am I wrong, or?
So, as part of the building permit, getting land use approval, a site plan is required. The site plan did show what the setbacks needed to be, of 25 feet in the front.
A site plan is not a survey, though.
Correct.
Okay.
So, it does mention in that document, there's a big highlighted area that says we do recommend a survey. We can't require, but we highly recommend, and if anyone would like to walk into our lobby, you'll see some rather vibrant, bright green signs that say the exact same thing, that we don't verify your setbacks. We highly suggest that you get a survey to make sure you're within them. That does bring up a point that we considered at staff level when this issue first came to us. We have a process called vested rights. It's a process whereby if there was an error on the staff's part, if the staff made a mistake and someone proceeded with a project and, you know, expended funds, there is a way to process that as a vested rights claim through the planning board and then the BCC. But in this case, there wasn't an error on the staff part. Again, we and building inspections, neither one of us verify the setbacks. That is completely on the builder. And as I said, going out to the site at first glance, you wouldn't think there's anything too odd about it. But the survey itself shows it is simply 1 foot off the property line. Given the rather unique situation of the layout of the right-of-way, the narrowness of the paving, like I said, it's not going to jump out at you at first. And the measurement for the setback was done from the edge of the pavement instead of the edge of the right-of-way.
And can you tell me why Escambia County has right-of-way widths?
So right-of-way widths, they vary, okay? For
What's the
arterial
purpose of them?
roads as opposed to collector roads and local roads. Local roads, generally, you're gonna get that width of right-of-way when a subdivision's platted, okay? That gives you that layout. For some reason, this is 60 feet as opposed to 50 feet, which you see more often in newer subdivisions. I wasn't here when that was platted. I can't explain why that is. There are just, some are wider than others.
What happens within a right-of-way?
What happens within a right-of-way? A right-of-way differs from an easement. An easement, someone owns that property and they're granting someone else the right to cross over, above, through, across. Right-of-way is simply essentially unowned land that anyone has the right to traverse. That's where your utilities are installed and buried, and anyone in an open public right-of-way has the right to use it for conveyance.
And as you stated, also, and there could be sometimes utility companies, many times they have to do some work in those areas. FPL, ECUA, sometimes the county has to come in and put more piping, so that right of way is basically, is set aside basically for those, sometimes road expansion. So they preserve that right to make sure that still county owned, utility companies, if they need to put in wires or anything like that, that is available for that individual home or for that community.
So the county can use that right-of-way for increasing road width, stormwater runoff,
Sure.
Utilities.
Any sort of infrastructure
Yes.
can go into a right-of-way,
That's a good point, yes.
as long as it's not blocking the purpose of the right-of-way.
Right.
In fact, I think, isn't it true that the reason you have right-of-ways is that very reason for utilities, stormwater, maintenance, all those items that are all part of the transportation system is.
Yes, sir. That is correct. And this isn't the first time this happens. There is confusion as to where does my property start?
Right.
Most folks don't realize that pavement is not the edge. of your property. That pavement is generally well within, though not always centered in, but well within the right-of-way.
I've always understood that you look to see where the electric poles are put. And if you do that, you can figure that's probably about in the middle of your right-of-way.
As a reference, yes, it's generally on the edge of the right-of-way, the power poles. Reasoning for that, you want to get, it needs to be in the right-of-way, but obviously you want to have it as far back from traffic as you can. Other things to look for are water meters. Where's the water meter? And-
Telephone boxes, that kind of thing.
Yes, sir. Yes, sir. And at this site, there are power poles. There's not a whole lot of other infrastructure items in that right-of-way. That's why I'm saying it doesn't necessarily jump right out when you drive by the site.
Do we have any more board questions?
I actually had a question for the staff. I've only been here about a year and a half, and on your recommendation, you didn't say yes or no on that. It was just pointing out two facts.
Correct. So, for staff to recommend approval, a variance needs to meet all the criteria.
Okay.
And this one doesn't meet 2 and 5.
All right, gotcha. Thank you.
Yes, sir.
Any more questions?
Mr. Chairman, could we see a picture again of the house?
Yes, I'm gonna, in fact, if you could pull up, so we can use those. So these are some photos. This is at the rear of the house, showing the impacts of erosion by that draw. Again, that was something I pointed out. Staff would say for any construction on this site, it would necessitate some sort of a variance, simply to keep as much of the erosion from the draw from getting into the wetlands. Would you click on that? So this is, again, the view looking from the pavement on Deerfoot towards the front of the house.
I have a question for staff.
Yeah.
Yes, sir.
Marty?
If I understand it right, the ROW is 60 feet, and it's more typically 50 feet. If it were 50 feet, would that mean that the house is within 11 feet of the property line?
No, sir. The setback is measured from the edge of the right-of-way. So wherever that right-of-way would be, it would have to come back 25 feet from that. So even if the right-of-way was narrowed, it still would require the measurement from the right-of-way
Right, but it
back
would,
in.
it would be 11 feet instead of the 1 foot that it is?
Yes, sir.
Okay.
Well, it would depend. I mean, is the right-of-way being reduced by 5 feet on either side, or?
I gotcha.
Yes, sir.
Okay, thank you.
I've got a question, sir.
Yes, sir.
And to your credit, you've admitted that you were mistaken.
Yes, sir.
And I would take it then don't have professional surveying experience or anything like that. Is that true?
No, sir, I don't myself. When I staked it out, I got the guys that did my slab, they come and sited it in, and I told them where to put it.
Yeah. So you didn't have a professional surveyor do it for you?
No, sir, I did not.
Until after
Yes, sir, correct.
the question arose?
Yes, sir.
Oh, okay. I have another question. Can we go back to the findings?
Absolutely.
Go on down, let's see, somewhere, you mentioned that there is, obviously, you can't have a zero lot line, I suppose, is what you're saying, but you did mention that the amount requested is more than the minimum necessary to use the land. Would you have any idea of how much property, or how much of a setback would be available that he could use, our applicant could use to build the property or to complete the property? Is there any, I mean,
So if.
we know zero is not the answer.
Correct. Yes, sir. If the situation had been one in which there'd been a survey and it came for land use approval, given the physical hardship of the land, the layout and that contour drop, staff would have absolutely been in support of some sort of variance to the setbacks. You know, we can do 20% administratively. This probably would require more than that and a visit to this board, but staff would have been in support. It would, simply because this actually has that hardship on the land. I couldn't say that staff would be in support of reducing the setback to 1 foot. That's a bit of a reach. The house could be moved back some, made smaller, wider, not as deep, something like that. There's a whole lot of unknowns there, and I wouldn't be comfortable speculating on that.
Well, if I understand, or maybe you can help me with this too, when you essentially have a zero lot line, the house would be, what, sitting on the lot line? Is that pretty much it?
It's essentially 1 foot back from the
Well,
right-of-way.
one of the things that we as a board have to consider is someone might build next to this lot, and you've got a house that is right on the lot line. I can foresee some problems if that should arise.
So
it's, I think there's more, while, we're sympathetic, obviously.
There's houses on each side of me already built.
That's correct. In that photo, you can see there is a house on that side. I'm sorry, wrong photo. Let me try a different one. So there you go. You can see beyond the sign there is a house that is on the east side. And again, this is taken from the edge of the pavement, not the right-of-way. That house does appear to meet the setback, but it's, how should I say this? I don't want to say it's an illusion,
Right.
but it does, at first glance, this one does not look to be simply a foot off the right-of-way.
When did you purchase the property?
Last year, September, October, somewhere back in there.
And obviously during the sale, the previous owner didn't have a survey or what
No,
have you?
ma'am.
I am having a hard time understanding how much complexity this property has with its topography. And a survey or you didn't reach out to someone to help you put it in the best place possible.
When I bought the property, I had it surveyed. I mean, that was the only survey I had done, was to buy the property itself,
Okay, so you had the property surveyed at
just to show
closing?
where my lot was.
You had the property surveyed at closing, or a boundary survey done?
Yes, ma'am.
Okay. During a boundary survey, when you go out to do a boundary survey, they mark the corners of the property for you.
Yes, ma'am.
So you knew where your corners were.
Yes, ma'am. Left, right, and both backside.
Okay, so you knew where your corners, you knew where your property line was, and you built 1 foot off of it?
I didn't realize that I was 1 foot off the right-of-way. I measured 30 foot from the edge of the road to my front door.
Okay, you said you knew where your property was, your front property line was, because you had a survey done at closing, right?
Yes, ma'am.
Okay, so that's your front property line. And you
Yes.
go from there to do your house. So what you're telling me is that you knew where your front property line was, and you built it on your front property line.
30 foot back from my property line, my front corner, to my front door.
Let me see the survey. Okay, this is your front property line that was marked on the ground. Can you show them where you can't see what I'm doing. Show him the front property line. Okay. The 4 corners of your property were staked if you had a survey done. These corners are staked every time a surveyor does a boundary survey.
I did not have a professional surveyor come and lay my slab out.
I understand, and that's fine, but you did say that you had a survey done at closing.
Not to show where my house was going to be,
I
just to
understand.
show where my property is. Yes,
Yep,
ma'am.
I understand.
Yes, ma'am.
So you had 4 corners of your property staked to do a regular boundary survey to
Yes,
close on your
ma'am.
property. By virtue of you having that survey done, you knew where your front property line was.
Correct.
Okay. And you built it a foot off your front property
I
line.
didn't realize I was a foot off that.
Do you know,
I know this is all my fault. I did not realize where I put it.
And
But I'm not causing any harm to anyone beside me or not impeding anything on anybody. I'm not asking for special favors or anything like that. I just want to try and finish my home so I'll have somewhere to live. And I understand I've made a huge mistake.
but
Moving it is
From-
not an
from
option.
me reading this and you telling me that you knew full well where your front property line was and you continued to build 1 foot off of it.
I did not know I was 1 foot off of it. I did
If
not
you-
realize that. All I knew was I had a stake up by the road, a stake up by the road. And I said, okay, let's go 30 foot back from there and put my front door right there.
you did know that Deerfield Lane, it's indicated a 66-foot right-of-way.
No, sir, I did not, but that was ignorance on my part.
I mean, well, did you have this drawing before you began your work? The one that's on the screen now?
No, I did not.
You didn't. This is after,
This
But he
is
had a
after the
survey
fact.
done at closing, and he had his property corners marked, because if he had a survey at closing, they would have marked his property corners. So he knew what his front property line was, his front boundary line was.
yeah. Any more comments from the board or questions?
I would just add that I agree with staff in the 2 and 5, but I also want to point out that also number 6 also applies to this situation. I disagree with staff on 6 in that it would not be injurious to the area or otherwise detrimental to the public welfare. That right-of-way is a right-of-way for a reason. We have setbacks for a reason. Whoever lives in that house, let's just say that somebody lives in that house, when they step out their front door, they're in the right-of-way. If the county wants to come in and put some type of
Infrastructure.
swale because of stormwater runoff, when he walks out his front door, he's going to go into a ditch. When Gulf Power, Florida Power and Light, or, I don't know, ECUA goes and wants to redo piping, sewer, water, what have you, we are in essence making a problem for whoever steps out that front door that there's going to be construction right outside his front door. And I do believe it is injurious. I believe it's going to injure whoever lives there.
That's gonna be me. And I don't have a problem with that. I mean, if I need to sign something to say I will not hold anybody responsible for any way or anything like that, I'll be glad to. All I wanna do is finish my home. Yes, I made a mistake, and I'm just asking you to please let me finish my home.
Andrew,
Yes, sir.
Obviously, as I said, the answer is not zero. What can we do? I mean, it's, that old saying, to err is human, and this has happened, and it really wasn't anything except just as it's been stated, it was a mistake. What can we do to help him realizing that we have to maintain the integrity of the right-of-way? I mean, I don't know the answer. I would hate to know that's either or. Either we say that it's all okay and, build on, or, I'm sorry, you can't proceed. I'd like to know that there's a middle ground or something that we can do to help. I mean, let's face it, life is like this, and here's someone that's proceeded in good faith and just really.
But I disagree with that. He did not proceed in good faith by virtue of the fact that he got a survey done and he knew what his front property line was.
Well, I suppose there is some.
If you know how to build a house, you know what your front property line is.
Well, I would say there's some merit in what you say. There's no doubt about that. But
If I may, so I don't have a whole lot in my toolbox to deal with certain situations. That's why I mentioned the first thing we thought of from staff perspective is this a case of vested rights? Okay, there have been other requests that have come to the staff in the past, that when we did our investigation, we realized that's the direction it needed to go. This one, there simply was not an error of omission or commission on behalf of the staff.
Right.
Which left us with only this process, this variance process. And as I've explained to this board many times, staff's findings are black and white. This board exists to address those gray areas. And this one's very basic. You see the situation. And I'm out of options
Right.
at this point.
And if I may, with our findings, Drew and I and myself, and we bat our heads. It's just challenging. We understand that the house is there. We understand that the cost is there. However, practically, houses can be moved. Seriously, I mean, it may be, that's a fact. I'm not saying that that's the way to go, but houses can be moved. It may be costly, but houses can be moved backwards. They can be moved forward. It may cost us some things. I understand that, but we are in a precarious situation. Ms. Batch, the points that you made, spot on. Drew and I, we thought about those things as well. We consulted with the county attorney's office about vegetable rights. There's no action on that part. But taking on, the houses can't be moved 5 feet back. For example, let's say our land development code does allow for a detached accessory structure. If there was backwards or something like that, 5 feet off the property line. That's what, for detached accessory structure. Code does allow for that. We do allow 20% from an administrative variance. So from the required yard. We do allow for porches per se to go into the setback area, so many feet into the setback area. So again, being that this is 1 foot off the property line, that is challenging, as Mr. Drew stated. We definitely cannot recommend that. But I know his point is that it's costly, but this is where we are, and I believe that this is what the board is sort of at a point. But houses can be moved. They can be set back. They can be moved backwards. But I know that's costly. I'm not saying that. I'm just trying to give them some opportunity for them to consider that being the case as alternatives measures.
I have a question, Mr. Chairman, for staff. What are the chances of something occurring on that road in front of his house where they would need to utilize the right-of-way right there in front of his front door? What are the chances?
So, I'm not with Public Works, okay? This is an established neighborhood. I don't foresee any sort of infrastructure projects that the county would be doing in there currently, or in the future. It would be a challenge on his side of the road if the county was to try to put in some sort of a drainage swale, given how all these properties slope to the rear. But I can't say with certainty that there wouldn't be a need. I just don't foresee it at this point.
I just want to just share this quickly with the board members. You know, we've had cases that come before us before where people, they make mistakes. Some of them did it intentionally. Some of them did it not knowing. And I don't know him personally, so I don't know if he did it intentionally or not knowing. But, you know, there is a such thing as grace, and I'm thankful for that. And because I'm sure everybody in this room at some point of time in their life have did something that they shouldn't have did, knowingly, but they got away with it. Some of them didn't get away with it. That doesn't make this situation right at all. But he is going through a hardship, and I think we should consider the fact that, hey, he's up here today, he's saying it's not staff's fault, it's no one's fault, it's his own fault, and he's saying that publicly. And if it's not gonna interfere with the right-of-way, I think we should really think on that.
And I do want to be careful. I don't want to say that this is or it's not. Because as Drew stated, that things do happen, but we want to be clear for the record. I understand what you're saying, but the possibility is there that that is what it was set aside for. So we just want to be clear going for that stuff. We're not saying that nothing not going to ever happen, because we, as Drew stated, we're not public works, so we can't really say that. I understand about grace. I believe in grace automatically. But these are the things that we got to consider.
So I do want to add to what Mr. Jones is saying. I'm looking on Street View along Deerfoot Lane, and drainage infrastructure is present on the other side of the pavement, the other side of the road. I'm seeing a culvert that goes under Goldenrod, a drainage swale, and culverts under driveways, all on the other side of the pavement.
My concern is not only the county, but you've got ECUA, you've got utilities, FP&L, you've got AT&T. There's no telling. I just wonder what kind of liability the county could face, if we do grant some variance here.
So, something else I'm noticing, all the power lines are on the other side of the road as well. And keep in mind, if this was a situation in that this structure was in the right-of-way itself, there's simply no way we would be able to deal with that, short of moving the structure. This is on his owned property. It's not in the right-of-way. The county is not gonna be responsible for things on his property, essentially. It's not in the right-of-way. While it's a foot off, it's still on his property.
And also, you're talking about moving how, I poured a monolithic slab. You don't move those. That's not an option.
Board
Besides the
members?
fact I don't have the money.
Yeah. Board members, are there any other questions or comments?
I have a question. The Public Works is not a part of the approval process in the normal sense of getting a building permit, is that correct?
That is correct.
Is there a way that this issue could be taken to the Public Works for comment? And I'm, for instance, ask the Public Works whether this is a problem to them.
I could, again, it'd be speculation, basically, because I'm not aware of any plans for any upgrades to the infrastructure in that area, and the infrastructure that is all on the other side of the right-of-way.
It just seems to me that although the house is on his own property, because it's infringing upon the setback, and there's a reason for a setback, with Public Works, would it be reasonable to ask Public Works if they're posed a problem? They would know more than you what's in the future, I would assume.
That, you're absolutely correct.
My second, it's not a question, it's a point. In my early life, I purchased a existing house, and during the survey for purchase purposes. We found that the front porch, which was an entry, enclosed entry, impeded on the setback. And so in purchasing that house, I was required to buy insurance so that if the county, it was the county area at the time, needed to work in there and damage my house, the insurance would cover it. So I was protected and the county was protected. Have you run across any issues like that? Any possibility of protecting the homeowner and the county?
No, sir, there used to be, and I'm sorry, it was in the old code, there used to be a provision regarding signs, and some sort of a hold harmless agreement, based on their location relative to the right-of-way line. But as far as a single-family home like that, I'm not aware of anything.
For the homeowner, have you talked to your insurance company on property insurance with
Well,
respect to this issue?
I figured until I got this issue resolved, they wouldn't even insure me, because what am I gonna? No, I have not. I was waiting to see if we get this, then I can go get the insurance on the property. I mean, when they shut me down, I said, and I'm thinking, because I can't get homeowners insurance right now because the county has me stopped. So if I get this variance, I can get the homeowner's insurance on my property and on my home.
I guess that's part of my concern is, if he goes ahead and finishes the house.
I can get
If you're
my.
paying cash for it, I don't see a problem, but if you're having a mortgage on this.
I
the
don't have a mortgage, but at this point, I'm to the point where I am going to have to go and get a loan to finish it, because I've had to bring in so much work, dirt and stuff done to fight the erosion that you could see on the pictures.
My concern is that, if you have to get a mortgage, will any mortgage lender, approve a loan, knowing that there's a problem with the location?
And Mr. Check, you brought up and we wasn't aware of this, that aspect of it. If he do have to get a loan, especially now, loan companies, they're calling us left and right about is these properties conforming. Many times in the new, they are requiring surveys. So those are the things that, as the director, I will have to get with you on proper legal on how to deal with those things, especially because they are calling us left and right about, especially if there are mortgages that are involved. And that's, I'm just for the record, they are, so that could be, because I sign them all the time. I'm not trying to cause any problems for him. I'm just saying that's something that I will have to consider going forward with legal assistance, if possible.
I am not taking a mortgage loan out. I'm going to get a personal loan. This is all I built this, when I sold my house, I built this out of my pocket. And I'm just gonna have to get a small personal loan to complete everything that I need to do. And then I will get insurance on it. And I will do whatever I need to do. I'm just begging you, please, let me finish my home, or I'm gonna be homeless and broke. And I will have nothing to leave my children. I know I made a mistake, and I apologize for that, but this was not something I did on purpose. The last place I want to be is here today. And I'm just asking you, please, let me finish my home.
Yes.
We understand.
I mean, I'm not trying to get over on anybody. I'm not trying to get fair. I made a mistake. I understand that. And I can't take it back. But I'm begging you, please, let me finish my home so I have something to leave my grandkids and my daughter.
Yes, sir.
I'm sorry about being so emotional. This is a bad week for me. This is my late son's birthday. And all I want to do is to provide for my daughter and my 3 grandkids. That's all I'm asking you to let me do.
Yes, sir. We appreciate your testimony, sir.
I understand.
Thank you.
Board members, any more comments or?
I wonder, I don't want to delay this any more than necessary, but I would certainly feel more comfortable if I were out at the site and looked it over myself. I may not learn anything from that, but being there would convince me that I've done everything I can to feel good about whatever my decision is going to be. I wonder if anybody else on the board has an interest in doing that.
Well, we would have to have a public meeting if there were more than one person. And that would be fairly involved, if I remember from my experience doing this.
It would certainly be challenging. We would have to, I mean,
You'd
due to
have to
sunshine
advertise
requirements.
and
Yeah,
all that sort of thing. It's not really, there were some cases on that back when I used to do this stuff, and
We did it before, and it's very challenging, as Drew stated.
there's
it's,
a lot of logistics there.
yeah,
Yes.
it's a lot of
Yes.
logistics. Madam Attorney, would there be a legal problem with one board member if he so wished, visiting the site, and then at the next meeting made a declaration, you know, to fulfill the requirements of the resolution and all that?
You're asking if this hearing can be postponed?
Well, I guess it would have to be, if we get to that point. I was just inquiring, Marty had indicated that he would like to see the site, and therefore we would have to continue it till next month. But my question was, would it
Provided that he makes a disclosure,
at the next meeting,
yes?
and a declaration of whatever he found and all that. Okay.
Mr. Chairman,
Yes, sir.
is that something we would vote on, to hold it
Yes.
off? or-
Yes, yes, sir. We would have to vote on this. This is a difficult case,
It really is.
if I might say so, and it's, of course, very emotional,
Yes, it
that's for
is.
certain.
It is.
Are there other comments?
I just want to say, I'm ready to move forward. I don't know about the other board members, but I think we should vote on this today. It's pretty clear what's going on with this situation. I don't feel going out to the site would change anything about the situation, and I feel comfortable with moving forward and going ahead and make a vote on it today.
All right. I do have one thought. If we do move forward with a vote, I would recommend that we include in that vote, should it be positive, and overturn the staff, that there, in this case, I don't think I can support this unless there was the homeowner would sign a hold harmless agreement that would relieve the county of any responsibility, because, you know, there are no utilities right there now, but the way this county has been growing now, check it out in 5 years or 10 years, and, you know, you may have road construction, brand-new subdivisions, I can see all kinds of infrastructure being put in, and it's just not, I mean, the home is on his property, but for me to support it, one of the key things that's going to have to be is that there's going to have to be a liability release for the county.
Whatever you need, draw it up and I'll sign it right now.
Just another question, Mr. Chairman. This area is surrounded by wetlands, correct? There won't be any subdivisions behind them or anything,
No.
would it?
No, sir, this subdivision is platted out as it is. The wetlands are to the north of him. But there's a mixture in that entire area of wetlands, everything. Essentially, Highway 29 and the rail line through there are kind of the high point dividing the drainage basins. So everything on this side is going to be draining to, in this case, northeast. That all goes to the Escambia River. So there's quite a bit of wetlands throughout there.
Thank you.
Well, I think our first order of business then ought to be to decide whether or not we want to proceed today. And I'd like to, maybe we could just have a consensus on that, and then wherever that leads us, then we would actually propose a formal vote. What's the board's feelings? Do we want to hear this, dispose of this matter today?
Yes.
We have a yes?
Yes, most definitely.
Yes.
Artie?
Yes.
Mr. Smith?
I'm not sure what.
Or would you prefer that we vote on this rather than continuing it?
Yes.
All right, and I too. I think in this case, continuing it is not going to.
It's not gonna change
It's
anything.
not going to help the outcome. All right, given that, do I hear a motion?
I make a motion that we grant the variance,
Oh, God, thank you.
With-
I'm sorry, what was that?
that we grant the variance.
Okay.
And Mr. Chairman, is it fair to say we can add to that motion that, the owner will be responsible for any, injuries or any bad outcomes, that may happen in the future on that?
Absolutely.
And so if I understand, you're seconding the motion?
Yes, if he adds that to it, yeah.
And you are adding the requirement that there be essentially a hold harmless agreement that would protect the county from any kind of liability associated with the granting of the homeowner's request. Is that right?
That's correct, as long as, that's part of his motion. That's
Could
correct.
you
I have no
also
objection to
please
that.
address staff's findings regarding criteria
What-
2 and 5?
Yeah, in just a second, I want to be sure we're, all right,
I'm sorry, Chairman. I do got a question about the whole harmless agreement, if that's where we're going. Madam Counsel, will that whole harmless agreement have to be approved by the BCC or just, because this is the first time,
Yeah, we have never taken that
right?
path. And
Correct.
so you're suggesting that the county and this gentleman enter into a hold harmless agreement?
right.
So-
That's my thought,
We-
and
we-
that the county is released from all liability relating to the
Mr. Chairman,
granting of a variance.
we do have a hold harmless that's codified, but that is regarding seawalls, okay? Shoreline armoring, as soon as you build a seawall, you start eroding your neighbors,
Right.
et cetera. But that is codified, that we take that to the BCC, and it's holding the county harmless for any impacts from that person building the wall. I've got nothing for a situation like this, and I'm certainly not the person who would need to be drafting that sort of
Absolutely.
agreement.
No, and I do believe that would require board approval.
Yes.
Because the chairman would have
Yes,
to
ma'am.
sign it.
Yes.
Yeah, I'm certain that it would. Well,
What I would tell you, should this board grant a variance, that is the county saying it's okay for this structure to be located where it is. And once again, it is completely on owned property outside of the county's right of way.
But you would need to address the criteria in the code.
Yes.
Because all of the criteria must be met.
Thank you.
let's go back to the criteria then. And Ross, I think you made the initial motion. Would you like to look at 2 and 5 and give us your thoughts on why you believe that that was an error? Yeah, 2 and 5.
Well, they aren't in error. They made their findings. I mean, he has admitted that it was his mistake. That's number 2. What was the next one? I'm sorry? 5, the variance granted, minimum variance, make possible reason of the use of the land, building and structure. I'm a property rights guy. I don't like the idea that a man has to come groveling to us for the use of his own land. I understand we have rights of ways and stuff like that, but we're here for the very point. If something happened, we can grant the variance. I've dealt with the city, the Architectural Review Board, a lot when building my house, and I just didn't like the fact that I had to go beg for simple things on my own land. I mean, that's just my personal thing.
So I take it then, from what I gather, are you saying that the variance that we would, if we would grant it, it would be the minimum that is the reasonable use of the building? Is that what you're saying?
Yes.
Okay. All right, we have a motion, we have a second, and at this point, we're ready to vote. You have heard the motion that is before us. Please raise your right hand if you favor this finding, these findings, and overturning the staff's findings.
And are you still including some sort of hold harmless agreement?
Well, I would like to.
Can we restate the motion, perhaps?
I would like to see that, I sort of got the feeling that I was the man that was on the island all by himself on that point, but,
Mr. Chairman, you're not. If we could restate the motion, that way we can be clear. And if that's added to it, I would second to it. Could it be that we approve it based on him going before the county commissioners? And then once they approve, everything is good at that point?
That is contrary to the land development code. And quite honestly, there really isn't any precedent for a hold harmless agreement going to the BCC from a BOA decision.
So in the past, I mentioned about signage in the old code. It gave 2 options if a sign was going to be located within, proximity to the right of way. It was a hold harmless agreement through the BCC or a variance through this board.
Okay.
Because this board holds that power to grant that spatial location.
Yeah, I would agree with Drew. If we're gonna grant this variance, you can't have your cake and eat it too. it is what it is. If something happens, you know, if he walks out his front yard and he sees that, you know, there's asphalt up to his house because we had to widen the road, I mean, I would,
So be it.
in essence, I would want him to not sue the county. You know, because that's what I see coming. That's our next step.
That's why I said I
And
will
hold
sign
on.
any.
Hold on a minute, okay? We're having a discussion here. And that's my concern here, is that we are making this an issue for later on that the county's gonna have to fight. And we allowed it to happen. I am totally in with, right to do whatever you want on your property, I get that. But we all have the same rules that we have to abide by. And those rules are set up not just for me, but for my neighbor, my across the street neighbor, for when I go visit a friend in their neighborhood. There is a logical reason for these rules. And there are safety reasons for these rules. I think this is a terrible issue. I hate that it happened. It could have been resolved fairly inexpensively in the beginning, but that's not where we are now. We are where we are, and we're a foot off of a right-of-way. And while we do grant some variances, unfortunately, there are just some that put the county, that put neighbors, that put others' safety at risk, and I'm not willing to do that. So I think that you either grant it as it is, let the cards fall where they may, or you don't.
Mr. Chairman, as part of the discussion, I would like to input that I agreed 100% with Jennifer. And I fear that in trying to help this gentleman, which I would love to do, we're creating a problem for the county, for the Board of Adjustment, and I think we're stepping into an area that is far above the job description of those of us on the Board of Adjustment. Thank you, sir.
I agree.
Are there any other comments?
And I would recommend, and if the counselor would explain again, because whatever direction this goes, you know, if it goes to the next step, then they're gonna need clarification as to why a motion was presented and what you saw as being incorrect in the staff's findings. And I think that's something that we'll need for the record and may need later if it went to a court.
Yes. Well, for my part, I agree that we'll drop my concern about a hold harmless. That'll makes it a simpler issue to deal with. Are there any other comments? Are there no more comments? All right. We have a motion to overturn the staff's findings of fact in sections 2 and 5. That has been seconded also, and by my calculation, if I'm correct, we are ready to vote.
I think so.
Are we all in agreement that we are?
Is the staff good with understanding why why the motion is against 2 and 5?
Correct.
All right. Then, ladies and gentlemen, all those in favor of overturning the staff's recommendation,
They didn't make a recommendation.
well, their findings, 2 and 5, is, well, technically you are correct. They didn't. Their findings, 2 and 5, are we correct? I guess I should have said. All those in favor, please raise your right hand. We have 2 in the affirmative and 4 in the negative. That motion fails. Do I hear a second motion?
I'll repeat myself. I feel uncomfortable on two situations. I would prefer to see the property before I would vote for, I should say, against the county's findings. And I would like, and I think also that the Public Works Department needs to be contacted and give them an opportunity to comment. Once those two things occur, then I would be more comfortable with voting for the existing motion.
If I understand the motion, then, Marty, is that you would like to continue this matter until next month, is that right?
That's correct.
Is there a second to this motion before we discuss? I do not hear a second. That motion fails for the lack of a second. Do I have another motion?
I have a question of staff. Drew, on this variance request, we have to find, correct me if I'm wrong, that he meets all the criteria, correct?
That is correct.
Okay. To your point, if you went out there, or if you talked to Public Works, number 2 and number 5 would still be an issue. There's no way that he could overcome those 2.
No, I could overcome those two.
You could overcome those
Yes.
2. No, not you, him, the applicant.
I'm not sure, I don't understand what you're asking.
On the criteria, he has to meet all the criteria. And as of right now, staff believes that he hasn't met 2 and 5.
Right.
Okay. Number 2 says that the special conditions and circumstances do not result from the actions of the applicant. He's already admitted that.
Right.
Okay, so, you see what I'm saying?
Yes, I do understand what you're saying.
Okay. And number 5 talks about a minimum variance that will be possible to be able to use the land.
I'm not sure how to respond to that. I guess,
I mean, he could have built a smaller house, he could have put it in another position, he could have done multiple things. So it's, I don't know what, do I know what the minimum variance? No, I don't know what the minimum variance is. But as we discussed, it's not zero, right?
It certainly, that's true, we found that.
Yeah, it's a conundrum.
Right.
Well, I think we're at the point now where the next motion, it would appear to me, Marty's motion for continuance failed. So we are at, it would seem, for the next motion would be to approve the staff's findings and in this matter. That would appear to be to me, the next motion. And
Isn't it by virtue of the fact that it failed that, or do we need a motion to approve staff's findings?
I would double check with Kristen, but typically if you made a motion and the motion, the greater of most was to not approve it, it would automatically be denied.
Right. I don't think we need to do anything else.
Or in the case of a tie as well.
Excuse me, Mr. Chairman, I'm sitting here staring at a picture of a house already built and we just denied. Where are we right now?
well,
That's what I'm saying, is there's a house right here and we're saying.
Well, we have denied at this point, as I understand, the request that the homeowner has made to us to overturn the staff's findings in 2 and 5. That's where I understand it to be.
And at this point, I'm sure the homeowner will go back to the county and say, okay, what can we do? If they come up with something,
Aren't we the county?
Perhaps to clean
We're the
up
county.
the record.
I've got nothing.
Right. I mean, and just, we will not have anything at this point. Again, it would be upon the applicant and to consider and to consider the cost of either removing house, it would be strictly on him, and that's,
yeah.
I mean, he would have to work with the building inspection department on that part, not planning and zoning about if it can be done, how it can be done,
Yeah.
which nothing is undoable. I can say that.
Yeah. I think we've done all,
I have one more, may I make one more comment?
Yes, please.
Obviously, the 6 of us have different opinions of this situation. The homeowner has one more option, and that is to appeal to the courts our decision.
yes.
And because I'm hearing physical concerns and economic concerns, and even legal issues, I think the homeowner needs to take this to an appeal if he wants to take it further. I think we need, I think it deserves legal court
Review.
decision.
If I may interject, it would be helpful if it is the will of the board to clarify the record, if there is perhaps a desire, if the intent was to deny the motion by virtue of it failing through a motion to disregard staff's findings, there was not a motion to approve staff's findings,
That was the point that I was making.
it would be a cleaner record.
Yes, I agree.
And whether you are agreeing or not agreeing with staff's findings, but all of the criteria would have to be met in order to grant it. So if there was a motion to deny, then the findings could either mirror staff's or something else to address the criteria.
So if I understand, then it would be in order for a motion to be made to support staff's findings.
No, if that is the will of the board, that could be a motion. But it's not a clean record, is all I'm saying, when the only decision that was made essentially was that a motion died.
Well, that was what I was trying to get to, was a finality in the thing.
So I'm not telling the board that you have to make a motion or that you need to do something, but I'm just advising you that makes for a cleaner record.
Well, that was my point, that was my question. Staff, I'm sorry, board members, do I hear a motion to support the findings of fact as presented by the staff?
I'll make a motion. I'll make a motion to support staff's findings of fact on 2 and 5 by virtue of the fact that in 2, the applicant admitted that he was a result of the action taken. Number 5, we don't know if it's the minimum variance. By review of the topography, I believe that a lesser variance could have been established had the house had a different house plan or a different location on the lot. And I would also add number 6, because by virtue of being 1 foot off the right-of-way, I believe it is injurious to the area and detrimental to the public welfare, being so close to the right-of-way.
We have a motion, do we have a second?
A second.
We have a second from Mrs. Smith. All those in favor of the motion to support the staff's findings as laid out by the vice chairman, please raise your right hand. And we have 2, 4, it's 4-2, and the motion prevails with 2 dissents. Thank you, sir.
What does that mean? I can't finish my house now?
Well, we can't tell you what to do or anything like that. You do have other remedies that are available to you.
You see that picture up there? All I've got on my roof is felt, and it's been that way for 7 weeks. And I'm just before losing the roof, my truss, and everything that I've done up to this point.
Yes, sir, we understand.
You people are putting me on the streets. I'm losing everything because I made a mistake. I'm just asking, let me finish my house. I will sign anything you want me to sign, that I will not ever sue anybody for anything or hold anybody responsible other than myself.
Unfortunately, that's not the
You
way it
people are
works.
ruining me.
Yes, sir. We appreciate your testimony, we really do, honestly. Thank you for that. But
So I'm just SOL. I can't finish my house. Is that what you're telling me?
no, sir, we're not telling you anything.
I can't get inspections. I can't do anything. I can't get a roof on it to protect what I've done. You suspended all my inspections. How am I supposed to protect what little bit I've done?
Yes, sir. We understand.
And so what? I just walk out and sit and twiddle my thumbs until I hear from someone else? I mean, what am I doing? Have I got to tear the thing down? I can't even sell the property. I can't do anything with it.
I don't know what to tell you. I would go back to the building department and
And what?
I don't know.
You either gonna let me finish my house or you have ruined me. That's the bottom line. All your little variances and grants and findings and this, that, and the other, yes, I understand that. But bottom line is, I'm trying to build me a house so I have somewhere to live and something to leave for my children. Yes, I made a huge mistake. People make mistakes. I don't know why you can't find it amongst yourselves I told you I would sign whatever you need me to sign, that I'm not gonna hold anybody responsible other than me for what happens there.
Mr. Holland, let's see if we can go talk to the building inspection department, because see, going on like, it doesn't do anything, so let's go see if we can, I don't know, but just going on, it's not.
Well,
what
they
you
just
really-
told me, no, I
I
can't.
understand.
Why am I?
Yes, option.
I hope y'all are happy. I hope every one of you are happy. Because you have just ruined me, my life, and my family. Every one of you, except for the two good ones over there. I hope you all sleep really good tonight.
Okay. Our next case is CU 2024-07.
I gave you the list.
Yeah, let's see. This-
Okay, this is the conditional use, CU 2024-07, that's requesting conditional use to allow the construction of a retail store greater than 6,000 square feet, yet no greater than 15 square feet in the RMU zoning district.
This is located at 6500 North Highway 29. Casey Feldner.
That's correct, sir.
Agent for Ron Scott and Laurie Scott, trustees for Ron G. Scott Revocable Living Trust, dated September the 10th, 2013, is the owner. You're Mr.?
I'm Mr. Feltner, Chairman.
Oh, all right.
Yes,
Thank
sir.
you.
I'm the attorney of record for the applicant.
All right, sir. Would you like to, first, have you read the findings of fact from the staff?
I have, Chairman. And I have to apologize to everyone. I am dealing with getting over being sick. I had I went out of the country and got food poisoning.
Oh,
So
no.
I apologize for the shakiness. Drew knows me pretty well. This is kind of out of character for me, so I apologize in advance. We have had the chance to review the staff findings, and we agree with the staff findings. And so I'm here, the engineer is here to answer any questions, but otherwise, we would defer to staff to make the presentation.
First, have there been any ex parte communications regarding this case? Seeing none. Has there been any knowledge or information obtained from a site visit or other sources? Seeing none. Is there any board member that intends to refrain from voting due to a voting conflict of interest? Seeing none. All right, sir. Andrew, did you want to?
Allison Lindsay.
Oh, all right.
Do we have any speakers for this case?
I don't believe we do. No. I
Okay,
think
so
Mr.
I would like to say that this, staff did review this and make all these findings for this case, and it did meet all the findings of facts. I thought maybe we could expedite it or if you wanted me to go through all the findings, but we did find that it did meet all the requirements for the conditional use.
Well, we would like to have some abbreviated
Okay.
for the record.
I'll go through the
Presentation.
map. So this is the map, the location map showing it at the corner of Molina Road and Highway 29. This is the zoning map showing the rural mixed use. And this is the future land use showing the rural community future land use. And this is the aerial map of the property. This is the public hearing sign that was posted on Molina Road side. And this is looking across Molina Road from the property. This is looking east at, on Molino Road from the property. This is looking onto the subject property from Molino Road. And this is looking west along Molino Road from the subject property. And this is the public hearing sign that was posted on Highway 29. This is looking onto the subject property from 29. And this is looking across Highway 29 from the subject property. And north also along 29. This is looking south along 29 from the subject property. And that's the photos and so the findings, so the criteria, compatibility, general compatibility, the proposed retail store would be conducted and operated in a manner that's compatible with all the adjacent properties, and the rural mixed-use district does allow for public facilities and services that are necessary in the area. And the site does meet the locational criteria. It's at the intersection of US 29 and Molino Road. And the location criteria is established with the rural mixed-use zoning district to promote compatibility among uses, especially new non-residential uses in relation to existing residential in the area. Facilities and services, it's Molino Utilities for potable water, and they will use on-site sewage treatment and disposal systems. So all public facilities and services will meet the capacity requirements, and it will go through a development review process. The on-site circulation for the ingress and egress, ingress and egress will be from Highway 29. It is a roads under Escambia County jurisdiction. The developer will need to coordinate access to the parcel with the access management during the site plan review process. For the nuisances and hazards, there should be no nuisances or hazards associated with the proposed use. In general, the proposed use of retail sales typically does not generate any nuisance hazards that would harm adjacent properties. For solid waste, based on the application documentation, solid waste containers will be available and located in the rear of the building, and they will be screened from view of the street. And it also will be confirmed during the site plan review. So screening and buffering. The submitted site plan that was provided shows a 16-foot landscape buffer on the property line abutting the adjacent properties. The criteria G for signs and lighting. The applicant states that the proposed lighting will support safety for vehicles and pedestrians and will be installed downward as not to reflect on the adjacent properties. The submitted site plan showed a proposed pylon sign, and the signage allowed in the RMU zoning district limits the number of signs available and the size of the signs, which contribute to ensuring compatibility with the community. All allowable signage calculations are also reviewed at development review. So for the site characteristics, the size, shape, location, and topography of the site appears to be adequate for the proposed use. The site requirements such as setbacks, heights, and landscapes will be met, and all site characteristics will also be confirmed during the site plan review process. Criteria I, use requirements. There is no additional conditional use requirements, and the applicant has submitted documentation that addressed all conditional use criteria, and staff recommends approval of the conditional use as requested, pending approval and receipt of a development order through the development review site plan process. And that concludes staff's findings.
And the only thing I'll add on top of that is this is a replacement pharmacy for Ron Scott. The original pharmacy is just right across the street. And based upon our calculations, we're asking for a little over 11,000. A very similar conditional use was granted just down the road for a General Dollar, I believe, not too long ago. So we tried to mirror that type of application throughout this process.
Do we have any questions from the board?
Was there a site plan?
There's engineering drawings as part of the packet.
Okay, so you enter, off of Molino Road, is that correct?
I believe so, yes. And 29. Yep.
That's all I had.
Okay.
Let's get another one.
Yeah. I have one question. There will be just one sign, is that correct?
That's correct. And we will meet the signage requirements. I've worked with the county on that before, so there will only be one.
Okay, because we've had this question come up before and with other kinds of businesses. And we always want to be to ensure there is just one sign for this rural area.
And I, in fact, was just working with Horace on something like this where there could be the potentiality of, multiple signs. One, that's not the case here, and number two, it would be addressed, I believe, underneath the accessory structures where it's not right next to the arterial roadway.
Right.
But right now, only one sign. I'm making this more complicated than it needs to be, so.
Right. Do we have any more questions? Willie, any questions? Marty, any questions? Mr. Smith?
No questions, sir.
Vice Chairman? Any more questions? All right. I guess we've reached the point where we need to decide how to proceed with this matter. Do I hear a motion?
I have to make a motion
To approve?
to approve according to staff's findings.
Do I hear a second?
Second.
We have a second. We have a motion and a second to approve the staff's findings. All those in favor, please raise your right hand. Unanimously, the motion passes.
Thank you all very much for your time, and thank you, staff.
Yes, sir.
Yep.
Our next case is CU 2024-08, 11236 Seagrade Drive to allow an accessory structure in the front yard of a waterfront lot. Lindsay Owens, agent for Sharon Cook, owner.
We do have a couple of.
Good morning to everyone.
All right, sir.
Morning.
Could you please face our clerk of the board, raise your right hand, and be sworn in?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name and address, please.
James Lindsay Owens. 4601 Clara Street, Pensacola, Florida, 32526.
And, Mr. Owens, have you read the staff's findings of fact?
I have
And are you in agreement with those findings?
every one of them.
All right, sir. Let me ask some questions of the board, and then we will turn to you and, if you'd like to make an opening statement.
Okay.
Staff, board members, we now turn to the question, have there been any ex parte communications on this matter? Seeing none. Knowledge or information obtained from a site visit or other sources? Seeing none. Is there any board member that intends to refrain from voting due to a voting conflict of interest? Seeing none. All right, sir, if you would like to make an opening statement, we'd be happy to hear from you.
Well, the purpose of this is to put a storage building basically in her front yard, because there is no backyard, because she's on the water, and it's just, there's no place to put it. And, we should have some drawings, I guess, of what, where we intend to put it and everything. It seems to meet all the criteria.
Staff, could we have your findings?
Hi, my name is Christina Smith, Urban Planner, and this is for conditional use case 2024-08. This is they are requesting to locate a detached accessory structure in the front yard on a waterfront lot. And so up here is a locational map of the property. This would be the zoning radius of 500 feet. This would be the future land use map. And here shows the airport overlays. This is the aerial map of the property. This is where the sign was posted on the property, and this is looking west along Seaglade Drive. This is looking east along Seaglade Drive. This is looking on the subject property. This is looking onto the subject property. And then this is looking across the street from the property. That concludes the photography for this case. Okay, so we're going to start going over the findings for criterion A, general compatibility. The parcel is a deep 346 feet plus or minus property fronting Big Lagoon. The proposal calls for an accessory structure to be built with a minimum 60 foot from the right-of-way and would be compatible with similar properties in the area. Regarding criteria B, facilities and services. Facilities and services for the accessory building are existing. Criteria C, on-site circulation. No new driveways are proposed. The applicant will use the existing driveway. Criteria D, nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, interference, or any other nuisances or hazards for adjoining properties and other properties in the immediate area. Criteria E, solid waste. Solid waste disposal isn't proposed for this accessory building. And criteria F with buffering. Screening and buffering between like uses, in this case, is a single-family homes, is not required by the LDC. Criteria G, sign and lightings. No lighting and signages are proposed. Criteria H, the parcel is sporadically adequate to allow for the home and detached garage. Criteria I, use requirements. A specified use requirement for this case is that the garage needs to be set back at least 60 feet from the right-of-way, and the proposal meets this requirement. And the staff recommends approval for this conditional use.
Board, do you have any questions for Mr. Owens? And then we will move to the staff for any questions. Do you want to hear any questions?
You stated there's no backyard, right?
No, sir. Well, there is, but as you can see, there's no place you can put anything.
Yes, sir.
It's just so very, there's a seat, basically a wall there, so.
And do the other neighbors, do they have, storages in the front of their yard, some of them?
I haven't looked at every one of them, but there
Okay.
are some, yes, that do have them in there. So.
No, okay.
And the one neighbor actually owns the same property. The one to the left of the picture there, she actually owns that property too, so.
All right, thank you.
So surely she won't complain.
Any more questions for Mr. Owens? I have one, Mr. Owens. This structure, will it have running water, electricity,
None of the
any
above.
kind of facility for bedding or
None
anything
of the
like
above.
that?
It's strictly a storage structure.
Okay. And so there won't be any habitation
No,
in
sir.
it at all?
No, sir.
How big is the structure?
Let me look. I think it's 16 by 30, I believe, if I'm not mistaken. I'm gonna find my notes here. I didn't bring the plans with me. No, it's 16 by 40, excuse me.
640. Yeah, there was one that had like a drawing.
Yeah.
Yes. Yes, ma'am.
Um,
That's, I have it here. That's this one. So,
And it is 60 feet from the front property. Sorry. It is 60 feet from the front property
That's
line
right.
to the edge of the accessory structure.
it's actually more than that.
It's actually more than that?
Yes, it's like 80 feet to it.
Okay. And then how close is it to the house from the structure?
About 20 feet,
20 feet?
so
Okay.
15 to 20. I didn't get that measurement, I apologize.
It's going where the existing. There's an existing one there, correct, that
Well,
will be
that's part
removed?
of the garage, that's the garage to the house.
Okay.
It drives in, it's just located.
But there used to be one there in front of it, right?
Yes, there was a small piece of.
Is this essentially going to be a garage with like garage doors and stuff, or is it just a
It's
building?
It's gonna be, yes, there's gonna be a garage door, a roll-up type, not a roll-up, it's an O-Team door,
Okay,
and a personnel doors too. It's just for self-storage.
okay. And the facade of the building, will it mirror the house, or is this a prefab building?
It's a prefab building.
Prefab
yes.
building.
It's a hardy board type siding on it. The house is brick, it's been there for 40-plus years. Be tough to match that one.
Are there any more questions for the applicant? Anyway, thank you, Mr. Owens.
Thank you,
We
sir.
appreciate your testimony. We do have several speakers also in
Okay.
connection with this.
Okay.
So we will hear from them
Okay.
now.
Okay, thank you.
Thank you, sir. Our first one is Ted Beaumere, and I'm sorry if I said it wrong, please forgive me and correct me.
My name is Ted Beamer. I
Oh,
live at
I'm sorry.
11228 Seaglade Drive. I live next door to the house that they viewed across the street. My mailbox is on the same mailbox post as my sister, who is requesting this. This is very difficult for me.
Yes, sir.
Sir.
Could you please face
Raise
our
your hand,
clerk and
please.
raise your right hand?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
In the name of God, I do.
Thank you. You may go ahead.
All right, sir, could you give us your testimony?
Yes, sir. Number one, that building is already there. It was put there before approval. It is not 60 feet from the county right of way. I've checked it. It would have to be moved back. The subdivision has been there for 40 or 50 years. I'm not sure. I've owned there for about 40 years since I bought there. It's an R1 old residential subdivision. There are school buses that come through and so on. The building that's being put in is being put in. I actually wanted to be last because I wasn't going to speak if I didn't need to because of my relationship. The building is not being put in for residential use. I can guarantee that. You can check the records for the county trash pickup there for the past 5 or 10 years. That site has been used, that residential property has been used as a commercial dump site for Decor Design Center, the company that she owns, a furniture company on the Key. Garbage is dumped there because it's cheaper to have the truck pick up there than to pick it up from her dumpster on her property, which she has on the Key. She had a run-in with Chandel, I believe it is, with their homeowners association because she had a rental house there that was full of furniture, and they finally put their foot down and said, get the furniture out of the house. She was using it for storage. Half of the Beamer Realty office, which I am at the moment a parcel of, we just lost my father here in October. The back half of that is a storage building for her furniture. The building that's on that property now, on the Seaglades property, that building they put there is from the front of her office on Perdido Key because she put in several storage buildings and they now block the front of the pretty building. I know without a doubt, it's my word, it's all I can give, and I have sworn, and I would put my hand on a Bible to it, that property will not be used, that building will not be used as a 40-foot long storage building for a vacant house. She didn't own that much stuff to put in it. It will be used for commercial use. All the neighbors know, the association knows, they've seen the Decor truck out there literally throwing furniture with glass onto the side of the way. If anybody wants to make a site inspection and go out and look at the county right-of-way in front of those hedges, they'll see broken glass and stuff from where she's been throwing this garbage. This is why I know that it is not just a storage building. The one she had might have been 12 feet that was there, dilapidated for ages. It was hauled out. A 40-foot structure sitting in front of that. Talking about putting a garage door on it that's not there now. That garage door on a building that's 4 feet off the ground, 3 feet off the ground, whatever it is a loading dock. That's what it would be used for. I'm absolutely against this building going in because I bought there as a family subdivision when I was in my 20s, when I was 25. I'm 67 the next couple months from now. And I bought this as a family place. And that's how I expect it to stay. School buses come by there. I really don't want to see furniture trucks bringing in stuff. They already do. To a great degree, they do. And I don't want to see garbage dumped on the side of the road anymore. I thank you very much for listening to what I have to say. If anybody has any questions for me, I'd be glad to answer. Thank you so much for your time and for the staff as well. I appreciate it.
Thank you, sir. Are there any questions for?
Where did you say you lived?
I live I've got the same mailbox post. I was there before she was. I live at 11228. If you look at the picture that shows the house across the street,
Oh, okay.
I'm immediately to the right of that. My mailbox is on the same post as Sharon Cook, who was once Sharon Beamer.
Okay. I just wanted to know.
Another word, just real quick. Several people were coming, but people just can't take off work to come here. My next door neighbor's a contractor. His brother has property in the neighborhood, a contractor. Our association president has requested, he sent an email to one of the people speaking, hoping that it can be read, that this man can be his spokesman, representative, or whatever term was used to let somebody else speak on his behalf for the sake of the association's view on this as well. So I'd appreciate if his words are allowed to be heard by the speaker that has that in hand.
Thank you, sir. We appreciate your testimony.
Thank you very much. You don't know how difficult this is for me. It's my sister.
Yes, sir.
I got a question of staff. Real quick.
Staff.
Yeah.
Who's got the question?
You're fine, sir.
Okay.
Has there been any code violations on this property that we're aware of?
I'm not aware of any. I can check. Some of the issues that were brought up fall under that realm and
Right.
as opposed to
Right.
ours.
I just
Okay.
didn't know
I
if
will
anyone.
check.
Okay, that would be great.
If I can make one last thing, If they want to check for code right now, they can go and check by the number of chickens she's got in the front yard, in a cage in the front yard. It's in violation because you're allowed 6 in the county. So just because there are no violations doesn't mean she's not been
Yes,
violating.
we,
So I just thought I'd point it out. Thank you.
we appreciate your testimony. I would like to hear from, I think we have an engineer representative here also, for,
That was for the previous case.
oh, it is?
Yes.
Oh, okay. Well, I'm old, so please work with me. All right. Our next speaker is Fred Kraus. I hope I did that one right. Mr. Kraus, thank you for coming. Could you please face our clerk of the board and raise your right hand and swear or affirm?
Yes, sir.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name and address.
Fred Frous, 11425 Seaglade Drive. Thank you.
Sir, what do you?
I'm going to
what
go
is
right
your
into it.
Thoughts on this?
What Ted said is directly on target, and I'm going to back up everything that he said. The petitioner in this case, Ms. Cook, runs a furniture business out on the Key. She uses this property as her dumping ground. I walk by it every day for the past 16 years, and for the past 10 years, ECUA comes out every week and picks up old couches, old mattresses, all kind of odds and ends from the furniture store. I was fixing to call in a code enforcement violation about a month ago when this structure got put in, because I knew it was wrong. Because no one else in this neighborhood has anything like this in their front yards. Not one house. There's like 60 houses in there, not one of them does. Has a big, huge open sign on the front of it, 3x5, like it's a business. Okay? It's a super high wind area. It's not tied down. It's like a mini mobile home. If you went out there and saw it, it's too bad staff couldn't have the latest pictures on it, but it's a mini mobile home in the front yard. It's 12 feet wide, 40 feet long, and it's about 35 to 40 feet from the property line. It's not 60, like they propose they're gonna do. They've already done it. So, excuse me.
Is there an existing structure? Is that what you're saying?
There's a home there. She doesn't live there. She lives next door. She moved out of this house a year or two ago. So she uses the house as a storage facility also.
The home is vacant. Is that your testimony?
That is.
And is there an existing structure already built that's the subject of this proceeding?
Yes, sir.
And
Got put
it's
there
there
about
now?
Yep, got put there 6 or 7 weeks ago.
Andrew, is that?
Could be 4 weeks. I'm just guessing.
Is this an after-the-fact permit?
Yes.
We don't have a permit on that. And I did check code enforcement. The only thing that I'm finding is code enforcement was contacted about an abandoned boat in 2011, nothing recent,
Okay.
so.
And the home itself is vacant? Is
Yes,
that-
sir, it is.
I don't know.
I have pictures on my phone if you would like me to walk in front of you and show you the structure.
Well,
You'll be amazed.
Andrew, this type of structure, it has to be permitted?
That is correct. As an accessory structure, okay.
So-
It can't be, it's not allowed as a accessory dwelling. It's simply a structure.
But it still has to have some type of permit,
It would, yes.
and it
yes.
goes through the
It's gonna require
the building department?
building permit, correct.
Okay. Has anything been submitted to the building department yet?
I'm not aware of that.
Mr. Kraus, could you just stand by a minute? Is Mr. Owens still with us?
I had to
Mr. Owens, can you come up just help us here a minute? Is there an existing structure?
That I have no knowledge that she moved the structure from in front of Decor Furniture there. I haven't been out there in 6 or 8 weeks. She hired me to start this proceeding. So there was, it was the structure in front of Decor for sure. I did not know that she had moved it out there at this point.
Step up to the
And
mic.
it's, and if she did, it's can't be where it's proposed to be. So I absolutely don't know, so.
Do you know if the home itself is occupied?
The home is not occupied, she does own it, and she is actually doing some work to remodel inside and things up and get it prepared for occupancy. I was fully prepared when y'all approved this to get a permit to move the building there, but apparently she has already moved it there.
Do you know if it's being used as a warehouse? That's sort of
The house itself?
Yes, sir.
No, sir. It's not that I'm aware of. I have been in the house and looked at some things in there for her. But, I mean, it's, you know, got a bunch of trash, I'll say trash, furniture and stuff inside the house, but it's not occupied, because she does live next door.
So you're not aware whether or not there is a structure there that's the
I did
subject
not-
of this
if it- I'm
proceeding?
not saying it's not there, but I wasn't aware of it. I haven't been out there and looked at it in 6 or 8 weeks, so,
All right, sir. Thank you for your help.
thank you, sir.
I'm sorry, Mr. Kraus, if you would
No
like to
problem.
continue.
Y'all want to see some pictures? You'll be amazed.
Yeah, they'd have to be admitted.
I can email them, I can text them.
How would we handle that if he wanted to offer photographs?
It's at the will of the board, but it would require a motion.
Yes, sir, yes, ma'am, I was just,
But,
since
you
they're
know,
on the phone, I didn't know.
of course, I'm sure you're all aware that, you know, that there would be authentication
Right.
concerns,
We go through
evidentiary
that.
issues, but it's at your discretion. So if you wish to receive that and take it into consideration, just bear in mind that there are certainly authentication concerns.
All right, board members, of course, we've not seen any photographs, other than what's been presented in the file. Is there an interest in the board, by the board, to have?
Mr. Chairman, I move that we take a look at the photo. I ordinarily wouldn't, but this seems to be a real contingent item here.
We would also, for due process reasons, need to be certain if there's a way to show it on the screen and allow the applicant the opportunity to review it and also
Right.
ask questions.
I was going to recommend that if
Yeah,
you
the
could
applicant-
email.
Yeah, the applicant that's standing right here has no knowledge whatsoever.
Well, sir,
So-
just hold just a second. If, my thought was if Mr. Kraus could email it to our board clerk, and then she could put them up for us all to see, I presume. Is that correct?
Yes, they can be emailed to me, and I can save them to the case file, and they can be presented up to the
But-
board.
But before we get into actually doing that, we have to establish the facts of the photographs themselves. Mr. Kraus, who took those photographs?
I did,
When did you take them?
last week.
Or I presume they're time-stamped, or,
Well, it's on my iPhone, I don't know.
okay.
I would imagine they are, but I don't even know if y'all need to see these to vote on it, but here they are anyway. Just so you can see that
Well-
this man's not telling the truth and this thing don't belong here. No other house in the neighborhood has this.
Well, what we're interested
It's
in
crazy.
is getting as much information as
Yes,
we
sir.
can to make a fair decision for the applicant and also
Yes,
for
sir.
other affected persons.
Yes, sir.
And if I've understood your representation of what those photographs contain, they show items or depictions that are material or could be material in our decision-making.
Yes, sir.
If that's true, I mean, we would perhaps be, if
I can
it's
email
the
it right-
board's will, we would admit them into evidence.
Yeah, I can email it right now.
I also wanted, short of that, any fact witness can certainly testify regarding matters, things that that a person's observed. Not testifying, offering any opinions, but strictly testifying regarding things that they have seen. That is certainly competent, substantial evidence to the extent that, you wish to consider that. So if
Board-
he were to describe what he's viewed.
Yes.
Does
Board
this-
members, what is the appetite of the board? Would you like to have these photographs emailed to our clerk for consideration to be admitted into evidence?
It might help if you would describe what the photographs are.
A picture of this structure. 2 pictures.
On the
Of the
property?
structure that
Yes.
is the subject of this proceeding.
Yes, sir.
I think that would be relevant if that's true. What is the feeling of the board? Willie, what is your feeling?
I agree. If that picture is a picture of the structure that we, concerned about, if it's the one that's the 16 by 40,
Yes,
if
sir.
that's it, I feel like it's really important for us to see it if that's what it is.
Yes, sir. That's what it is.
Well, if I can speak for the board, then would you like for Mr. Kraus to email those to our clerk now?
Didn't you make a motion? I make a motion that.
All right, do I hear a second?
A second.
We have a motion and a second. All in favor? Please raise your right hand. It's unanimous. Ma'am, Miss Rachel will help you do that.
Thank you.
And while we waiting on that, Mr. Chairman, I have a question, also, concerning HOA. Do you guys have to get, buildings and stuff approved by the HOA, also? And do the HOA, allow, commercial, businesses, in the subdivision?
We're LDR, so, no, you can't put a second structure on the property without permission, without permitting, and if you're familiar with LDR.
Yes,
Yeah,
yes.
you can't do that.
Okay, thank you.
Yeah. I have a statement from the president of the homeowners. He wanted me to read it. I'm not sure if I can even do that, but if I can, I'll be glad to do that.
I would kind of caution the board on that. Yes, sir.
Generally,
Yes.
we don't permit, it's essentially
Yes,
a
sir.
petition. You can't examine a petition.
Yes, sir. I just had to throw it out there. He texted me on the way here this morning because he couldn't make it, and I said, I'll ask. So,
But we appreciate the thought.
yes, sir.
Rachel, are you having any luck?
Yes, I'm just downloading them to the file.
Okay.
You said that your HOA don't allow that. Have they do they fine people when they don't obey the rules, or? No?
No, this subdivision's been here since Gulf Beach Highway got rerouted through that area, and it's just a bunch of old houses, old-timey folks.
Okay.
It's like Mayberry, like Andy Griffith Mayberry area. It's real laid back,
Okay.
so. But I can tell you, there's no
Okay.
other structures like that.
Mr. Kraus,
Yes, sir.
Miss Rachel has your photographs. Why don't you tell us no opinions, but tell us what they depict?
The picture to the right, where it says open, is a view through my passenger window of the structure. Where the bushes are is basically the property line. And then that structure with the big open sign is about I'm gonna say 40 feet. I'm in the construction business, so I'm saying it's about 40 feet, maybe 35. And then the second picture to the left is when I pulled into the driveway and I was sitting on the edge of the right-of-way. And that's a picture of all the junk on my dash, shot through the window of the structure.
Is the gray building with a white door the structure that is the subject of this proceeding?
Yes, sir. It has a gray roof with a light green finish and windows and doors. Looks like a mini mobile home, basically.
And the house that we're seeing in the left picture, that's the house on the lot, in the same lot, or is that the house next door?
That's the house to the west and behind.
Oh, okay.
And there's a chicken coop there to the left, that little cagey thing. Yes.
To your knowledge, did it, or did you see any sort of electrical connection or anything like that?
It was blocked, where it was set down on blocks, but it wasn't tied down with any kind of tie-down structures. It's ready for electrical. It does have, you can see in this picture to the left, it has wiring inside of it for lights and outside, but that's as far as I went. Didn't go any further. That's why I was gonna do code enforcement, let them plunder around. And once I saw this sign go up, I just stopped calling code enforcement.
And so it's your testimony that commercial activities are being carried out from the home, is that right?
I haven't seen anything go in and out of the home, but I've seen all the debris come from the furniture store and put on the right-of-way to be picked up by ECUA for the past 10 years. Like hundreds of mattresses, hundreds of couches, cardboard boxes, end tables, you name it, it's been on the right-of-way and picked up by ECUA for umpteen years.
All right.
So,
Do we have any more questions for Mr. Kraus?
oh, I did a good job.
The applicant, it's not a question for him, but can we make, just for the record, is that the actual site that we're looking at? I mean, is that's not a fabricated picture, that is the site?
Yes, sir, that is the site.
Bingo.
But I have no knowledge of that building being put there. I applied for this back in March. I hadn't, didn't get, so they could be ultimately put there, so.
Mr. Kraus, we appreciate your testimony, and thank you so much, and we appreciate you presenting those photographs there, to add to our knowledge.
Yes, sir. Thank you.
All right, sir. And our last speaker is Terry Ostergren.
Can I ask a question first?
Yes. Sir.
Oh.
I,
Oh, wait.
okay.
want to speak, but I will if I have to.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. State your name and address, please.
Terry Ostergaard at 1433 Cacao. I'm in Seaglades neighborhood.
Yes, ma'am, and what do you know of this
Well, I
application?
walk this street and ride my bike all the time, so I see it. And it's a nice little neighborhood, nice and clean, and the one thing I would hate to see, that structure is there. I saw it when the tow truck was there, putting it back. And I would hate to see precedent set to where everybody loads up with these structures. We have enough of that on Gulf Beach Highway. So,
Is it your testimony that you have seen the gray building with the white door that we have just seen photographs of
Yes,
at that site?
yes, just the other day.
Okay. Yes, ma'am. Is there anything else you'd like for us to know?
No.
How long do you think that building's been there?
It's been several weeks,
Okay.
a few weeks.
And have you also seen the trash on the,
I have.
you have?
There was a couch and other stuff out there the other day.
Okay. All right.
Thank you, ma'am. We'll,
Okay.
no more,
Yeah.
any other questions for the, thank you, ma'am.
Okay.
I have a question of Drew. If in fact this is the case, and that building was placed there, is it our responsibility to notify code enforcement or the building department as to something that is in violation?
So code enforcement is complaint driven. They're the ones who will research and determine if there is a violation. I don't have any kind of permit history for the structure on site or in its previous location, which is quite visible on street view. It would be up to this board if the board as a whole wanted to make a code enforcement complaint, or the neighbors, that would be the avenue. Someone would need to make that request of code enforcement to investigate. It appears there's a myriad of issues here, besides this one structure that has been moved to the site.
Well, I don't see how we can approve an application for an unpermitted building.
So the request that's before you is to allow an accessory structure in the front yard of a waterfront lot. That's the request before you. The other issues regarding the status of the building, where it is, where it came from, and any of these other issues concerning accusations of commercial activity, that would be all matters for code enforcement. What's strictly in front of you is the land use issue of an accessory structure in the front yard of a waterfront lot.
I feel like they don't need the land use. They already took it upon themselves to do it anyhow.
Right.
I think it's fair to say if we could make a motion to withdraw the application.
That's
Be-
up to the
because
board. Yes, sir.
I don't see how we can consider granting this application to allow an accessory structure that apparently is illegally placed. I mean, that sort of flies in the face of reason, you know? That's just my feelings. Board, are there other comments about this one?
Mr. Chairman?
Yes, Marty.
I understand where you're coming from, and I agree with you. I think that the solution would be lack of a motion. Lack of a motion
Would be like a tie. They're here seeking an affirmative resolution.
And your staff has recommended approval
So
of the
you would-
conditional use, and you would need to address the criteria.
I think we're dealing with two different issues here.
Yes.
We're dealing with one issue, yes, there are some violations there, and I believe that those need to be taken care of, and regardless of what happens with those violations, if that's something that we as the board can say, hey, we think there's some code issues, we'd like you to check it out, or however that goes down that way, I think that really is a separate and a part of this person wants to put a shed in their front yard, whether or not it's this shed or whether or not it was placed with permitting or whether or not it was placed in the right place or what have you, is something for the building department to deal with, is something for code enforcement to fine, is something for the other departments to handle. I think there's two different issues. And I think unfortunately, and that's why I asked the question, is we didn't know any of this was happening until someone brought it to light, a violation, if you will, not only a violation of a building permit violation, I guess, but other violations. You know, is it our responsibility to notify the right department that there is a violation, and then go to the second part of, would we allow this building, this accessory, allow unaccessory structure on a parcel of land that is a waterfront parcel?
And Ms. Bass, if I address applicant, you are correct what everybody was saying, but the thing is this: if the BOA does grant land use approval, my staff will review it for the site to make sure it complies with the land development code regulations prior to it receiving BID permit. If it does not meet my side of the house with the granting, with setbacks and things were supposed to be, we won't grant land use approval. So therefore, BID cannot issue them a permit. And if BID don't issue a permit, then that automatically can trigger a separate review, because that building just can't stay there. Then the neighbors can call code enforcement, and if they do come in to comply, we will put that this is for residential uses only, known commercial uses. If they violate that, then if a complaint, code enforcement will get involved then. So the protocols are in place for the neighborhood to address their concerns as far as there's a violation. But prior to it receiving a land use approval, if conditions approval, we will put all those, gotta be residential, all those things. And if they violate that, it's strictly on them. And you it's strictly the BOA to see if they want to grant a accessory structure, conditional use in the front yard on a waterfront lot.
Let's go back to the findings, please. Let's start at A. Let's see. I'll tell you what, can I pass the gavel to the vice chairman? I want to,
Okay.
I'm going to move that we overturn the staff's findings of fact, beginning with A, there has now been conflicting evidence as to whether or not it is a minimum of 60 feet from the right-of-way. And it's certainly questionable whether, in my mind, it's compatible with similar properties in the area if the testimony that we've heard that there's a business being conducted out of it. Let's go on down a little bit, please, ma'am. To D, I believe that from the testimony we've heard from more than one person is that this is being used as a dump. So surely there is a nuisance and a hazard there. And let's go to E, I believe it is. There's question about whether or not that is correct, because apparently the solid waste disposal is now taking place on that lot. And that has been the testimony, and that surely is would seem to create a nuisance condition. And let's go on down. And now the question has arisen in I, whether or not the requirements of the applicable zoning district, it would seem to me, and use is in fact correct. I believe those are the things that the staff obviously did not know, because you can't know what nobody tells you.
Madam Chair, I second the motion.
And therefore, I believe that we should overturn the findings of facts based upon the evidence that has been presented, both testimony and actual physical evidence, photographs and such.
Does anybody have any discussion?
I have a question I would like to ask Drew on something, because he's expert on these things when it comes to timetable. Let's say, since there are some allegations allegedly about code enforcement activities, let's say that code enforcement go out there and the applicant basically clear up everything, and it's the only thing that they need is go through the proper permitting process. If this board deny the conditional use approval, can the applicant come back to this board again? If all of the allegations have been cleared up, if they are correct, can they come back again and request the sitting of an accessory structure on a waterfront lot again? Or will this completely disallow that, or is there a timetable?
180 days, if it is a denial by the board. Yeah, there's a 180-day prohibition on them reapplying.
Or the applicant can withdraw
Correct.
his application
Correct.
and come another day.
That is correct. And as you pointed out, there are two issues here.
Right.
Okay, there's the
Correct.
conditional use, simply the structure, and then there are the matters for code enforcement, and at the board's will, if you all want to be the ones to initiate the complaint process, I would need you to direct me to do so.
Can I direct you to do so right now, sir?
Absolutely,
Okay, thank you, if you would, please.
I will.
What is that now? I'm sorry, I had a senior moment.
That was a request for code enforcement to get involved.
Oh, yes,
Yeah.
exactly. Ms.
So that-
Owens.
It will go in under my name, but because I'm,
Mr. Owens, can you
request.
come up? Do you understand what's going on?
Yes, ma'am.
as far as the board goes.
I absolutely do. And may I speak first?
Yes.
Okay. Yep, Sharon Cook, Gigi as I call her, had asked me to apply for this for her back in March and said, first of all, can I even do this? And I came in here and talked with Drew and the other people there, and they said, yes, it can be done. And I made application. I sent her the paperwork to fill out because I didn't have all that information.
Right.
So as far as whatever's out there now, I don't have anything to do with it. I didn't put it there. I'm not operating a business out of there. I'm strictly here to get this through there. Now, at some point, I am a state certified general contractor. If she was, and I know we have to permit that sort of stuff, or it would never have been there.
Right.
So,
Mr. Owens, I'm sorry.
Do you have the gavel? Do you
No.
want it back?
I'm sorry. No.
Just don't throw it at
I don't
me.
want to. I can't. I'm old, please.
A motion has been made, okay, to deny this. And according to what Drew said, you have 180 days. After 180 days, you can come back and reapply for this.
If the board votes to deny it.
If the board votes. Or you can withdraw, because apparently there are some issues that maybe need to be cleared up, and then come back next month.
I
That
would
is
vote
kind
to
of,
withdraw.
you would like to,
Let's just withdraw it until I can speak with Ms. Cook and find out what's actually going on.
Okay.
I think that'd be the best thing to do.
okay, and that is totally up to you.
But I think that's what we should do. I'm in agreement with that.
And Ms. Jennifer, and I don't wanna set a definite time for it to be back next month, because
No,
we never know
yeah.
what code enforcement time
Yeah.
schedule, their schedule and.
Right.
And
I was just
going
saying
out there.
that if he withdrew, he could come sooner than 180 days
Yes, ma'am.
if it went wrong. Okay, so,
And I've also apologized for the inconvenience of this, but by the same token, I think it's gonna help the whole neighborhood, because there are obviously some problems there.
okay.
Thank you, sir.
Then the board, we don't have to make a motion or anything, do we?
Do I need to sign something withdrawing, or?
I think our
Those
motion
motion
needs to be
obviously made to
withdrawn.
deny.
Oh, yeah.
So you gotta,
We do,
You have to
so
deal
he
with
would-
I withdraw my motion.
Okay,
Okay. Next case.
Yes.
okay, next case, and I'm passing the gavel back. to
Okay,
Laura.
I can't.
So at this point, if you do decide to reapply, you'll just get back with us and we would restart, all the neighbors would be re-notified, new signs and all that.
Yeah, no,
Yes.
this will
Thank
be
you.
eye-opening here for her.
understanding
Certainly
that,
was for me.
Drew, you gonna make, send it
Thank you,
to us.
Mr.
Thank you.
Thank you, Mr.
Apologize for taking up all the time.
All right, thank you, Mr. Owens.
Thank y'all.
All right, our last case is CU 2024-09, 4825 Mobile Highway to allow a restaurant not among the permitted uses. Fred Coulard, agent for Gulf State Storage of Mobile Highway LLC, is the owner. And is Mr., oh, there you are, sir.
How are you, sir?
Welcome.
Thank you.
Could you please face the clerk and raise your right hand?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name and address.
Fred Chenard, 4825 Mobile Highway.
First, I need to ask the board, have there been any ex parte communications concerning this matter? Seeing none. Has there been any site visits or other information concerning this matter? Seeing none. And is there any member that will not be voting due to a conflict of interest? Seeing none. All right, sir. Have you read the staff's findings of fact?
I have.
Are you in agreement with them?
Yes, sir.
All right. Would you like to make some initial comments, or would you like for the staff to make their presentation?
The staff can proceed.
All right, thank you, sir.
Good morning, Board. My name is Caleb McCarty. I'm a AICP certified planner for Escambia County. Our first presentation here is a location map. You can sit down, sir, if you like. You can sit down. This is our 500-foot zoning radius map. It's commercial zoned. This is our future land use map. The future land use is also commercial. We provided an easement map for clarification on any questions, along with an aerial and the general aerial of the location. This is our public hearing sign that was posted on Mobile Highway. This is looking north along Mobile Highway, looking onto the property from Mobile Highway, looking south, I believe it's a Tom Thumb, or now Cumberland Farms. Where is it? Just bombed out. All right, this is looking east across Mobile Highway. Also looking east, give another perspective. This site has two frontages, so we placed another sign along Tonawanda Drive. Provided some photos there, looking west along Tonawanda. Looking onto the site from Tonawanda. And looking east along Tonawanda. And south directly across Tonawanda. That completes our photos. We'll provide some information related to staff's findings. In total, we found that it did meet all criteria, but I'll provide a brief summary related to those criteria. So the applicant is seeking a conditional use approval to allow for restaurants not among the permanent uses of the commercial zoning district. Concerning criterion A, general compatibility, we found that the proposed conditional use as a food truck court could be conducted and operated in a manner that is compatible with adjacent properties. The sites along Mobile Highway, which is a principal arterial roadway, and Tonawanda, a minor collector road. Commercial uses are found along Mobile Highway and abut the subject property that are compatible with the proposed use. There are residential uses in the subdivision to the west and south of the subject property. Criterion B, facilities and services. We found that the facilities and services will be available through connection to ECUA. Permanent restroom facility is referenced on the site plan proposed, and a public facilities and services for the proposed use and the capacity requirements will be reviewed during the site plan review process as well. Criterion C, on-site circulation. Based on the submitted site plan, ingress and egress will be provided with a connection to Tonawanda, and no new connection was shown to Mobile Highway. According to Escambia County maps, there is an existing access easement on the property that accesses Mobile Highway from the property, hence why we provided that map. We're suggesting, therefore, that the utilization of this easement would be recommended to decrease the potential impact on the residential subdivision along Tonawanda. Furthermore, any proposed impact to the existing access easement or placement of structures, parking within the easement will need to be verified with the easement owner and with guidance from county transportation and traffic personnel. Preliminarily, vehicle and pedestrian safety, on-site circulation, traffic flow, and emergency vehicle access appear to be adequate for the proposed use. We do note that evaluation is needed by county transportation personnel to ensure maneuvering of trucks is satisfactory, as well as on-site circulation. And that will be done at the site plan review process. Criterion D, nuisance and hazards. Outdoor seating areas are shown on the proposed site plan. Provisions of the Land Development Code do does not allow for making of any noise or sound that exceeds the limits in the LDC or county noise ordinance. In addition, air pollutants, glare, vibration, and other nuisance hazards are addressed by the LDC and must be met. Criterion E, solid waste. Proposed location of dumpster enclosure appears to be visible from the public right-of-way. And we note that it will likely need to be moved to a more suitable location. Solid waste services must be provided as needed for the proposed use, and we'll do that again at the site plan review process. Criterion F, the subject property does not abut residential uses, and there's therefore no screening buffering requirement at LDC at this time. Criterion G, signs and lighting. The project will utilize low voltage lighting according to the application, and signage along Mobile Highway and Tonawanda is proposed. Exterior lighting should be deflected from adjoining properties into public streets. Signs and lighting will be evaluated again at site plan review. Criterion H, site characteristics. We found that the location appears to be adequate for the proposed use. Criterion I, use requirements. There's some specifics related to mobile vending units that are outlined there. Won't go into the details unless questions are asked there, but essentially, mobile vending units require temporary permits from Escambia County at the time that one's brought onto the site. But we wanted to reference those particular use code for you there. So in summary, we did find that the proposed use, we do recommend approval with the following conditions. You must complete the DRC process and the receipt of a development order from the county, and the permits obtained for the individual mobile vending units will need to be obtained from the county. That concludes our maps and presentations and findings for this.
Do we have any questions for the staff?
Can you explain this access easement? Where'd it come from? Who gave it? What? It totally blew my mind, and I couldn't
Sure.
figure it out.
Yeah, the applicant may be able to speak to that. From a staff perspective, there's easements on a lot of property. And you know, whether it be vacated or whether it be utilized on the site. Again, that will be in conversations with traffic personnel. That'd be vetted at the DRC, you know, concerning any type of impact. And sir, you may be able to speak to that easement if there's anything associated with it.
As far as I know, that the property was all together. It was sold, that parcel was sold to Babcock Furniture, and Babcock built on it, and Mr. Liberis bought the easement with the property back 10, 12 years ago.
So the owner of the subject property owns an access easement that is shaded in yellow, on here.
Yes.
So he owns, wrap my head around here. He owns an access easement that traverses whatever property is next door.
What's
But-
the function of it? Right, I'm not quite sure. Just from our review and a little bit of history here, we have seen site plans for the Babcock from years ago. There were some proposals. This property had been split up a couple of times, so there's a survey that was provided at the site plan. The easements are shown. There's descriptions of the easement. Again, really at site plan review is, you know, if the current owner owns it, I don't know if they maybe vacate it or, you know, provide what it actually allows. So that would be addressed at that point. But we really don't have any comment other than, you know, we wouldn't allow anything in it right now until that's vetted.
What is that building, the big white building?
That's Babcock Furniture.
Oh, okay, it's a
Mhm.
furniture store.
Yeah.
And then on the other side, it's a gas station, I believe?
Yeah, they're Cumberland Farms.
And the only access to this, what are you calling it? A restaurant facility, is off of Tonawanda Drive.
So again, the applicant may be able to speak to that. The site plan submitted to staff shows access off of Tonawanda. From our understanding and conversations with county transportation, Mobile Highway is a state highway. It is likely, and then of the opinion of county staff, that the applicant would likely not get approved for a driveway, an additional driveway onto Mobile Highway. If that would so occur, and you may be able to comment about that, sir, then the county couldn't deny access, and therefore the access would likely be where it is shown on the site plan.
Okay. And in here, it talks about, not being next to residential, but isn't it across the street and adjacent to a residential?
Technically, the abutting properties are all commercial and commercially used. If you look closely enough, we couldn't say that because due to, directly to the west, there is some type of private right-of-way. If you pull up an aerial, Rachel. So technically, it's not abutting, the aerial with the parcels. That is not a parcel there.
Okay.
That just goes back to the folks in the funny-looking one there to the northwest. It's just some type of private right-of-way, like a dirt road. I think you can see it from the
Does
street
anybody,
views.
who owns that?
I don't think it's owned, it's just not zoned, it's just right-of-way, like a private type of right-of-way. Drew?
It's right-of-way that was, I think it was an alleyway in
That was
the
vacated?
no, it's still there. The subdivision plat was from the early part of the 1900s, and it didn't have as much information as we would have today, but that's where,
Right.
when we tried tracking this down, I found it on that plat.
But across the street is residential homes.
Yes, all that
Correct.
on the south side of Tonawanda is residential.
And to the southeast, that parcel there was the one that came last month, drive-through restaurant request on there.
Oh, the drive-through and something else?
Correct.
Was it the one, there was like a dentist or
Right.
something?
Yeah.
That was the
Yeah.
Chick-fil-A.
Yeah.
And from our research, the property just north of Badcock came through in 2016 for a variance because it abuts MDR and it's a drive-through. I think it's in Dunkin' Donuts. So when that happens, it requires approval from this board. It was approved as a variance. Just a note there. And another comment related to the access, regardless if this was restaurant, outdoor type of use, if this was a straight permanent use in the commercial zoning district, that being allowed by right, we would still be looking at potential access off of Tonawanda. Any type of commercial, if they couldn't get a driveway on Mobile Highway, again, that's unlikely.
And obviously it was advertised and we didn't have any phone calls on it?
I think we may have one person speaking. Okay. I did receive a phone call from the property owner to the north, in full disclosure, that had questions, concerns related to the proposal. And they were explained that they can come and speak for, against, or whatnot. So.
Mr. Mr. Chairman, I think that's all the questions I have.
That's all the questions. Is there anyone else on the board that has questions?
I know it's been a long morning, but, what would the hours be? I mean, what would be, by that being a picnic, I think I saw a picnic area in there and a sitting area. What would be the hours, in that, area?
I was thinking maybe Friday, Saturday night, 8, 9 o'clock at the latest.
Okay.
Any more questions? Well, and we have no speakers on this. I think we're at the point now where we can take this matter and decide. So,
Make a motion to accept staff's findings of fact.
I have a motion.
Second.
We have a second. All those in favor of accepting staff's findings of fact as presented, please raise your right hand. And it passes unanimously. Thank you, sir.
Excellent. Thank you guys for your time.
Yeah. Well, Drew, what's on the program for next week? Next month?
Yes, what do we got?
So the next meeting is gonna be May 15th. I have 3 cases so far. One is just like a recreational, outdoor area for a subdivision. Another is for an educational facility, and then the last one is a salvage yard.
Is a what?
Salvage yard.
Oh, a salvage yard. Okay.
I think Drew signed up for that one.
Yeah.
No.
Okay, Madam Attorney, do you have anything you'd like?
No, sir.
No, sir? Okay, well, we appreciate the board's hard work, and I know that we've had some difficult cases this morning, and I just want to tell you how much I appreciate everyone's help. I know we haven't always agreed this morning on the outcomes, but we've had some very good, in my opinion, questions and concerns. And so I just wanted everyone to know that we may not agree, but I really think we function well as a board. Okay, I guess we're adjourned then. Yeah, that's right. Who wants it? Who wants to be chairman? Yeah, that's right. Jennifer's gonna be our chairman.